we are learning in the BRS MLA's disqualification case, the Supreme Court has served a notice to the Telangana Assembly Speaker. Well, the Supreme Court has now questioned the delay by Speaker in deciding on the disqualification of the MLAs, and the court has asked what is the reasonable time to decide. It can't be a case of operation successful and patient dead. Well, the Supreme Court has slammed Telangana Speaker's inaction in the matter, and it was hearing the plea against the Speaker that was filed by the BRS in this case. Well, 7 BRS MLAs, remember, had joined the Congress party after the polls. And to talk more on that, I'm being joined by Uma Sudhir, my colleague, and also Nupur joining us from the Supreme Court. Nupur, if I could come to you first, important observations that have been made by the court today, and also strong words that have been used by the Supreme Court saying that it can't be a case of operation successful and patient dead. Take us through the details. What happened in the court there?
Well, the Supreme Court today has come down heavily on the counsels appearing for Telangana Speaker. The Supreme Court, in fact, on previous 2 occasions in the hearing has refrained from issuing a formal notice and has asked the Telangana Speaker to come up with a reasonable time frame and tell the court that what would be the reasonable time in which he will be deciding this disqualification petition, and has said that it can't be that the petitions are pending till the end of the term. Now, today the counsels appearing for the Speaker, in fact, informed the court that they could not file a proper reply since there was not a formal notice. Now, today the Supreme Court has took a dim view of this argument and said that to avoid any technicality and any doubts, it will now make sure that notice is issued and served to the Speaker and ECI in these pending disqualification petitions. And in fact, today Dr. Senior Advocate Abhishek Manu Singhvi was appearing on behalf of the Telangana opposing the BRS petition, and in fact he said, I have experience since he has already fought for Congress-led coalition in Maharashtra. And in fact, today the Supreme Court made this very interesting remark. Since the defecting MLAs have joined Congress now, the court now said that now it appears that the victim wants to be the perpetrator. So it is a sort of a dig on, from the top court on this whole defection fiasco. Because at the time of Maharashtra defection, Congress alliance was at the receiving end. Now it is the BRS party that is at the receiving end, and it is Congress to which the MLAs have defected. So it is a big development, and in March, the Supreme Court on March 25 will take up the case again.
All right, absolutely. Let me go across to my colleague Uma Sudhir also here. Uma, well, notice now has been issued to the Telangana Assembly Speaker in this case, but the outcome of the case is expected to have some serious political ramifications in Telangana, and this could also serve as a precedent for other cases.
See, soon after the assembly elections in Telangana in November 2023, after which the results had come, we saw about 10 MLAs in fact shift loyalty. Some of them even contested on the Congress ticket after shifting to the Congress party. Some of them contested as parliament candidate as well. All this has, raised question marks in the minds of the people. Yes, we have seen cases in the past where people have shifted to another party and have even managed to become ministers there. And case in point is the BRS itself, which in fact accepted defectors from other parties and even made a minister. But now the shoe is on the other foot, and the BRS has gone to court asking for why these people should not be disqualified and why the election should not be held for all those constituencies where the people, where the elected MLA had in fact shifted parties. So while this is politically sensitive, the court had asked that to be decided within a reasonable time, and that is the definition that everyone was waiting for. But the lawyer arguing this case, that the Aryaman Sundaram, saying that the constitutional mandate has not been fulfilled by the Speaker by not reacting to this and by not giving a judgment in this particular case, his own judgment in this particular case, and therefore now the court has issued a notice to the Speaker, and therefore the Speaker is now expected to respond to that notice that's been issued by the court.